to be more direct and precise, I will deal in particular with the topic of the so-called collective countermeasures. That's to say, the forms of decentralized reactions to violation of erga omnes obligations in international law. So we have to assume that in the case of Crimea annexation, there are all the elements for considering that the general regime of international responsibility and of consequences of erga omnes obligation violation apply. That's to say, we assume that we are in front of a violation of an erga omnes obligations, that's to say, to an obligation owed to the international community as a whole, and a special grave form of violation amounting maybe to an aggression or to an illegal territorial acquisition by the use of force. This is the first assumption. The second assumption is that we are confronted with the reactions by a certain group of states, mainly Western states, sometimes organized in an international organization, the European Union, against this grave violation of international law. So we have the involvement of the so-called third parties in the reaction to a violation of international law. This is the basic factual assumption. Well, what is the legal regime applicable to this kind of situation? We have to refer to the some general principle codified in the 2001 draft articles of the ILC, International Law Commission. In particular, we must underline that the regime of the reaction to erga omnes obligation is rather complicated under that text, in the sense that we have at least three provisions relevant for defining such a regime. The first one is Article 41, and dealing with particular consequences of a serious breach of an obligation under this chapter, the chapter dealing with obligation arising under peremptory norms of general international law, so violation of jus cogens norms. These articles provide for a series of solidarity obligations, that to say an obligation bearing on all the states of the international community affected by the violation, the grave breach, the serious violation of jus cogens. We have different kinds of solidarity obligation. One of such obligation will be dealt, I think, in the next panel, so I will not consider here that's to say the obligation not to recognize the legality of the situation created by the grave breach. For our purposes, it's sufficient to mention the first paragraph dealing with the obligation of state to cooperate, to put to an end through lawful means serious breaches of jus cogens or peremptory norms of international law. So there is a first obligation of cooperation to put an end to the illegal situation. First step. Second step, second article, which is of some bearing for our purposes, Article 48 of the draft articles, dealing with the invocation of the responsibility. I try to resume very quickly the basic idea of this norm. The basic idea is that there are some obligations owed to the international community of states as a whole, and in face of the violation of such obligation, all states in principle may have an interest, a legal interest, to invoke the responsibility of the lawbreaker state. And this is in particular dealt with in Article 48, paragraph 1, letter B, the case in which the obligation breached is owed to the international community as a whole. In this case, the not directly injured states are entitled to apply, to invoke all the consequences of the violation of international law. But this provision tried to diversify the entitlement of not injured state, in the sense that such state not directly affected may invoke the cessation of the violation and also assurances or guarantees of non-repetition and also reparation, but in this case not in their proper interest, but in the interest of the victim of the breach, in this case Ukraine. In our hypothesis. Well, this article, as you can see, doesn't consider another form, another kind of consequence of an international wrongful act, namely countermeasures. This topic was considered in a separate article of the draft, Article 54. But in fact, Article 54 does not provide an answer to the fact, to the question if not injured states are entitled to having recourse to countermeasure or not. This is a non-prejudice clause. That's to say, a clause that doesn't prejudice the right of any state entitled to invoke responsibility of another state to take lawful measures against the state to ensure cessation of the breach or reparation in the interest of the injured state. Note the strange formula, the strange expression, lawful measure. Lawful measures are something different from countermeasures, of course, and the expression was not chosen incidentally by the IRC. It was chosen exactly to cover both the case of typical lawful measures, that say retortions, so measures that are not forbidden by international law and are not contrary to international law, and also countermeasures properly, that's to say measures that in principle are wrongful, are contrary to an international obligation, but may be excused, may be justified if they are taken in reaction to a wrongful, initial wrongful act. So this clause does not prejudice the question. Leave the question open. Why leave the question open? This is the explanation that you may read, I hope, no? Okay, this is Article 54. Yes. The explanation given by the International Law Commission for the adoption of such a non-prejudice clause was that the practice of collective countermeasures is too sparse, is uncertain, so it is not possible to have a definitive conclusion about the admissibility and the permissibility of collective countermeasures in international law. That was the situation in 2001. So, after this very quick presentation of the basic principle applicable to our case, let me just very quickly mention what the Crimea crisis and the case of the Crimean annexation may add to this practice that in 2001 was considered by the International Law Commission as sparse and scant. Previous speakers have already mentioned various kinds of sanctions, reaction adopted, so no need for me to come back to the content of such measures. Very quickly, just to recall that such measures can be classified according to a according to a progression. In a first phase, I refer here mostly to the measure adopted by the US and the European Union, of course, but they are not the only states having adopted such unilateral measures against Russia. In a first cases were targeted measures directed against individuals involved in the political turmoil in Ukraine. This is a very first phase of the crisis. In this phase, maybe it is difficult to consider proper countermeasures, such kind of restrictive measure adopted by US and European Union, but in a second phase, in which the events bringing to the Crimea Declaration of Independence happened, well, the attitude of US and EU changes, and we have targeted sanction directed in a more evident way against a person having governmental responsibility or military responsibility, important military responsibility in the Russian organization, and so the targeted sanctions in this case are directed more explicitly against Russia, and their intended purpose is to put to an end Russian occupation and of Crimea. That was the second phase. These aspects of reaction to an international wrongful act and a serious international wrongful act committed by Russia is even more evident in the third phase of the sanction, that to say, in the executive order adopted, for example, in December 2014 by the US President and by the European Union Council still in December 2014, and dealing explicitly with restrictive measures adopted in response to illegal annexation of Crimea and Sevastopol. So, in this case, in the last phase of sanction, it is clear that we are in front of countermeasures adopted against a state for its breaching very important norms of international law. So, can we consider that the Crimean crisis put some new element in the legal regime of collective countermeasure? Maybe yes, of course. We can conclude that we are in front of a series of clear countermeasures adopted by so-called third states, that to say states not directly affected by the International Wrongful Act, and such measures correspond to the typical function of countermeasures in international law, that to say are measures intended to put an end and to oblige the wrongdoer state to comply with its obligation of cessation and reparation. This seems to add and to contribute to the consolidation of the category of collective countermeasures that was left open by the International Law Commission in 2001. But there is still one aspect that seems to be rather controversial, that to say the institutional element or the coordination element in the adoption of collective countermeasure. Of course, we are dealing here with an extra institutional dimension. We are not in the context of the United Nations. The Security Council was paralyzed, so no question of having an institutional action. But some form of coordination is, of course, required also when countermeasures are adopted in a decentralized context. Such coordination may be may be very essential in order to ensure that countermeasures respond to some basic condition, among which there is proportionality, of course, And in this context, we have not to forget that we are also dealing with a serious breach of jus cogens obligations. So in this case, it is pertinent also, it is relevant also Article 41 that I recall at the beginning of the presentation, envisaging some form of cooperation to put an end to the wrongful act. This form of cooperation means probably also some form of coordination in the taking of countermeasures. From this point of view, the Crimea case has very, very few indication and clarification to the overall regime of collective countermeasure in international law. Well, I hope to have
Thank you very much.
Respected the time. Thank you.
And also thank you for sticking to the time limit designated to this panel. Matthias, Hartwig, floor is yours.
Thank you very much. Thank you very much. I will make happy our chairman because I learned this morning the great part of what I wanted to say to you already have been said by Lukasz Ruszyński. So I will limit myself just to one slide and a few words. I will not make you listen, but I will make you think. The problem I will explore is, of course, the question of sanctions under the regime of the WTO. And here I will focus on Article 21, which already has been quoted this morning. I will try to interpret it with you. Perhaps I will propose an interpretation, and I hope in the discussion we will find something. Nothing has been decided on this topic by now. There have been some panels under the WTO, under the GATT, since 1949, the first, and then in the 80s, Nicaragua 1, Nicaragua 2, Helms-Burton. All they dealt with the question of 21, but there was no final report on it. So no definitive decision on this question. And so this is on the one hand a pity. It makes my task quite difficult. On the other hand, you know, we have as lawyers now full leeway, and we can use our imagination, and I will try to do so. What is how has this article been used by now? The United States have a very clear stance. They said when they took the sanctions again against Nicaragua in the early 80s, they said these sanctions are not trade related, Therefore, they do not fall under the GATT at the time. Do not fall under the GATT. So they just rejected any competence of the panels, and they did not participate in the first case, Nicaragua case. In the second case, they changed a little bit their position, said, okay, it is hard to hold the position that it's not trade related, so there might be some competences, but the question of the measures here, specifically the measures taken in time of war or other emergency in international relations, they are not subject to the jurisdiction of the panel. Here, the state has full power, full freedom to interpret these notions. And what are the notions we find here in it? There is, if it considers nothing to Brent. Yeah, no, there's something is missing. Sorry. If it considers, nothing in this agreement shall be construed to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests taken in time of war or the other emergency. So if it considers necessary and emergency, these are the most important notions. And here, necessity, of course, you can say the panel has the competency to check if there is a necessity. But on the other hand, it's not said if it is necessary, but if it considers it necessary. So there's a strong subjective element in it, giving the states some discretion to determine on their own if it is necessary to take such measures which might be not directly in line with the requirements of the WTO. And here the possibility of an interpretation in favor of the states. And the same is of course true with respect to emergency war or emergency in international relations. If it considers this necessary, it includes a possibility to determine what is an emergency situation for the given state. There have been some decisions also recently where one panel took a position not specifically to Article 21 but to Article 22, the general exception. It is there to permit one member to abuse or misuse its rights. It's a case, United States against, in the Schum's case, to permit one member to abuse or misuse its right to invoke an exception would be effectively to allow that member to degrade its own treaty obligations as well as to devalue the treaty rights of other members. So if you say it's the full discretion of a member state to decide what if a measure is necessary, then every state can anytime refer to this provision, say, no, I do not want to respect the rules. And this would be the end of the story. But even if we take a closer, if we accept that to a certain degree and say, okay, the panel has the possibility to check it, nevertheless, we must see that it is set if the state considers the necessity, so there is still quite a space for discretion for the state. Now, taking the situation of Russia, here it's that it's in a case of war or emergency in international relations. If we say it is an emergency in international relations for one side, then we must say it's also an emergency for the other side. If it's a war for one side, it's also a war for the other side. So we could come to the conclusion, if we declare, as this morning has been said, yeah, we have good grounds to say there is emergency for one side, then it is also then we must come to the conclusion also emergency for the other side. So Russia can refer to Article 21 with the result, no violation of WTO when it took the sanctions. Now, second step is the question of countermeasures. Countermeasures, because the general law is there, perhaps a violation. Countermeasures are illegal acts. If we come to the conclusion this is legal, no countermeasure. So Article 49 following, in the draft on the state responsibility that just does not apply because it is not an illegal act, it's not a countermeasure in this strict sense. So this could be the end of the story, no violation. And now I would like to try to offer a different interpretation and in a way to combine the notion of countermeasures with the interpretation of emergency and the necessity. And here the question could, of course, cannot be that we say if it is in violation of the countermeasure, then it will be also a violation of Article 21. Because if it is, then we have a vicious circle. Because if it is not a violation of 21, then it's not a violation of the provisions on countermeasures. It's not violation of the provisions on countermeasures, then it's not a violation of Article 21. So no result. But I would like to capitalize on the idea behind countermeasures, and this is that the state taking a countermeasure must be injured. And here now the question will be, who is injured? Injured by an illegal act. And now the question will be, can a state, if we pick up this idea of the injured state, can we say that if a state who is injured, who is at the origin in the sense of the emergency, can it refer to the Article 21? And if we say no, such a state cannot refer, then we come to the conclusion that if we hold that Russia violated the principle of the prohibition of the use of force, then it cannot refer to the emergency because it is at the origin of this emergency. can, in this case, violation of Article 21, also the other, better to say, Article 21 would not apply, it would be no exception, Russia could not base itself on this provision. However, there's still a problem. Who will decide on it? It is a panel. It is a panel, and these panels, they are composed not even of international lawyers by force. You know, there are many of them just economists. And how can they decide on general questions of international law? It's a question of international law if we are in an emergency in international relations or if we are in a state of war. So therefore, this is on the one hand, it would be certainly limit the possibility to refer to it if we said a state which is not injured, but is at the origin of the emergency cannot refer to it. But then the panel had to decide it, and I would say, unfortunately, these panels are not qualified to decide these questions. So, in the end, it is difficult. It's very difficult, to my mind, to come to the conclusion here that stated by the panel that Russia violated the WTO. Thank you very much.
Thank you very much. Now, we have already had the chance to listen some Russian views, some Ukrainian views, Polish Western, and now we'll have an opportunity to listen a Belarusian view on the subject of our consideration during this panel. Professor Alena Douhan, Belarusian University, Minsk.
Thank you very much. Ladies and gentlemen, it's a huge pleasure for me to be present at this conference, and I would like to thank organizers, first of all, for invitation and organization. I won't follow the example of Dr. Hartwig, I will speak. And by the way, I will try probably to propose you a different perspective when looking at the situation as such. I would like to look whether the whole reactions of international community, of every member of the international community, I mean all the parties involved, Russia, US, European states, was correct. Whether all parties did everything they could, or at least everything they should, to prevent deterioration of the conflict. It has been rightly noted by Theodore Christakis yesterday that unfortunately in the last 20 years international law has been violated that often that sometimes we started to think that when it concerns some high values it's justifiable in some way or maybe sometimes even legitimate because we seek to reach some higher humanitarian goals. And it was also discussed yesterday whether there are analogies between Yugoslavia and Crimea situation. And I want to say yes, there are analogies, but not in the way we have discussed yesterday. There are also lots of analogous stuff with situation in Afghanistan 2001, with situation in Iraq 2003, with situation in Libya and Syria. And the analogy is that international law has been violated in bigger or less measure. And unfortunately, it has been violated in Crimea situation as such. And now we come to the point that one or other strong states violate repeatedly international law. Why in this situation, what could prevent Russia in this situation to think that, well, they have violated international law and there were no serious consequences. Why not to do in the same way? It's not legal. It's not, it can't be just a good justification for violation of international law, but basically it's a standard way of policy making. If they do not suffer consequences, probably we can do the same, violate international law a little bit with having some really good sound and humanitarian justifications, and to reach our purposes we want. And we all realize that no state in the modern international law will ever violate international law directly. No one will agree, we violated international law. Definitely, there is no black and white situation. There are certain justifications which could be invoked by both parties. But the point is whether these justifications are sound. and what are reactions of the international community to these sound justifications. And we shall always remember that, unfortunately, despite all the efforts and despite all the claims, no humanitarian intervention by this moment has been purely humanitarian. There is always some sort of political interests of different states in this situation. And then I come to the key topic of my presentation, where the international community, where the European states, where the international organizations, in the first case, did what they should to settle the conflict, did what they should to prevent the deterioration of conflict. And unfortunately, probably I will abuse everyone, but no, they didn't. If we look at the development of the situation, well, at the moment when we have just started, when the development of the situation in the southeast has just started, it wasn't Russia who said that we want this peace of situation. No. Even when Lugansk People's Republic and Donetsk People's Republic said, we want to join Russia, Russia said, no, there is no legal ground. You need to find your special status within Ukraine. Ukraine at that moment, I don't know the reasons for political decisions, or maybe they are clear in the situation of the immediate loss of Crimea. They were not ready to propose a special status by that moment. And the situation started to deteriorate. Then another point. Unfortunately, if we look to all the development of the problems, I had a feeling that the most of international organizations at that point were more interested to make Russia guilty in everything than to prevent deterioration of the conflict. Do you remember what has happened when Malaysia and Boeing had failed? At the same day, there was a claim that Russia was guilty. In a day, Russia presented some pictures, some echo recording, and then it was said, oh, maybe we were wrong, maybe there was a mistake committed by Ukrainians or someone else. So the point was that if Russia was guilty, yes, it shall be punished. But we need to make an investigation and know who was guilty in this situation before we start to accuse. Because these unsupported accusations do nothing good to settle the conflict. They just deteriorate the whole situation. And unfortunately, only when humanitarian situation, and also let's recall the discussions in the UN Security Council. If we look at the records up to, I believe, September 2014, the issue of the Southeast has nearly not been discussed. Russia has initiated discussions repeatedly, but finally it came to the point that quite a lot of member states said, well, yes, it's bad what is happening at the southeast, but Russia was bad in Crimea. So basically no real steps have been discussed to start settlement of the conflict. And unfortunately, I had a feeling that political interests of different states prevailed over suffering of human society, over suffering of particular individuals in Ukraine from any party of struggling sides. Unfortunately, international community started to react only when humanitarian situation in Ukraine has become disastrous. Now, according to the data of the United Nations, more than 6,000 people are officially dead. But I'm afraid that their real records are much higher. So let's look how international community, different organizations reacted in this situation. If we look at the UN Security Council, as I mentioned, the problem of the Southeast has not been discussed for a long period of time. So the most of the problem, although the UN Security Council had meetings on each stage of the problem. So in general, the UN Security Council was able to adopt only 2 resolutions. A resolution after the aircraft crash and a resolution on the peaceful settlement of the conflict, the main purpose of which was to endorse the packages of measures, basically the implementation of Minsk agreements. So it's already a good step forward to find this solution. If we look at the activity, as concerned the UN General Assembly, it adopted a single resolution calling not to recognize the referendum in Crimea. However, in general, although in accordance with the rules of procedure of the UN General Assembly, it was adopted, Only 100 states of 193 states of the UN General Assembly voted for it. So in general, half of the states voted for these resolutions. All the rest didn't want, or didn't decide, but in general, we can't say about unanimous support of the resolution, whether it's good or bad. As concerned the UN Security Council, to tell the truth, I was really surprised why there was no attempt made by the Under-Secretary General or whomever in the office of the UN Secretary General to act as a mediator, to propose good officers. Well, in general, I have heard even at this conference how funny your president in Belarus was. He fried eggs and made coffee in Minsk. But he did his best he could do to settle the conflict. Probably he couldn't do anything else. But here, the UN Secretary General did nothing to propose any sort of activity he usually does. If we look at other UN bodies, it's also strange. One, the special monitoring mission has been established by the UN High Commissioner on Human Rights only in April, when the situation from humanitarian perspective has already been bad for several months. As concerns Organization for Security and Cooperation in Europe, basically, despite all the critique toward this organization, it was the only organization which has been actively involved and tried to do its best for the settlement of conflict. I mean, establishment of different sorts of monitoring mission, reporting every day about the results of monitoring. So it tried. Probably it hasn't succeeded, but it tried to be impartial and to present the information. And we know that information is very important. As concerns the Council of Europe and the European Union, unfortunately, because of the shortage of time, I can say a lot, they didn't do that much. They mostly blamed Russia, but didn't try to propose certain solution of the case. And, sorry, I just need to move further. As concerns the humanitarian outcome, here are the figures from the PASER resolution adopted in January 2015 and the UN Security Council resolution, records adopted in March 2015. It has been mentioned 6 million people in the Ukraine need humanitarian assistance. More than 600 people are refugees. 600,000 people are refugees. 1.1 million are internally displaced persons. So there is a really, really high need for humanitarian aid. But unfortunately, and I come to the last slide, unfortunately, all the steps which are taken until now are either halfway or still with the use of double standards. As an example, the European society as well as the United States accused Russia in supporting weaponry and providing military assistance and other steps. Yes, it doesn't help to settle the conflict, but at the same time Russia accuses European states and United States in doing the same. And now the question. There is a mechanism at the UN Security Council to impose armed embargo when no one can provide heavy weapons or anything like this. And the question is, why haven't this legal mean no member of the UN Security Council has even proposed it for discussion? The answer is clear. Everyone wants to have the possibility to do this, other than to prevent everyone doing it. It hasn't been discussed. As concerns the humanitarian aid, Russia is accused in graving humanitarian situation, although we need to remember that even to the information from the PASER, more than 500,000 people, refugees, flew to Russia. So maybe it's easier for them to find the asylum at what is called aggressor. So maybe it's not that bad for them being over there. And accusing Russia in doing this all, can you compare the numbers? More than 500,000 and 11,000 in the whole Europe. So probably Russia is doing quite a lot of good for humanitarian assistance, as well as different other forms of humanitarian assistance. Then, the international community has not agreed about a number of legal points. Illegal armed groups are understood absolutely different by different parts. We all agree that if there are illegal armed groups, they shall be punished. But in the situation when it's convenient, everyone who is struggling in Lugansk and Donetsk are called as illegal armed groups. If we think so, why do we think about the plans to exchange all for all, to decide not to do any criminal investigation for fighters from both sides? So maybe it's just a method of political activity. The same concerns the qualification of crisis. The same concerns all other matters. That's why, yes, I understand. I come to my last point. So if the international community, unfortunately, hasn't done what it could and what it should for settlement of the crisis and for prevention of deterioration of the crisis. And I would agree that Russia is at certain measure and in a larger measure guilty in what is happening, but it's not the only one who is guilty. So the point is that it's a higher time to act legally for everyone around to settle the conflict and not to sacrifice legality on behalf of certain political interests. Thank you very much.
Thank you very much. I have to restrict myself not to enter into debate. Just one comment only. We should be very careful not to take reality we read from the press and the media as a full picture, because there have been a lot of proposals made through diplomatic channels since the February 2014, made in the way to find the diplomatic solution of the conflict. For various reasons, they were rejected in the way. Now I would like to give the floor to Alexander Sashenko from Kaliningrad.
Can you hear me? Yes. First of all, my name is Alexander Salenko. I'm representing Baltic Federal University of Immanuel, Kant in Kaliningrad. The topic of my presentation is Crimea right of secessionist self-determination and reunification with Russia. But yesterday, after all presentations, I decided to change the way how I'm going to present. Basically, I'm ready to agree with my Western colleagues and say, yes, Russia violated international law, and you are right in all perspective, and it was really a grave violation of international law. But you have only one but little problem. The population of Crimea is not with you, not with Western partners, not with US partners, and this is a little conflict of interest. So on the one hand you have this, and I have impression from today and yesterday that this is a kind of society of legal fundamentalism here. So on the one hand it's really perfect and blameless and perfect legal logic and argumentation on the one hand, so that Russia violated international law, annexed Crimea. On the other hand, the reaction from the Crimea's population, it's another opposite point, and you have to deal with this. And this is the same impression if you go to the end of the Soviet Union, to the dissolution of the Soviet Union. It was the same situation. If you decide legally, if you would be adherent of this fundamental legalism, you would declare that this self-determination of Ukraine, it was totally illegal due to international law. Let us remember what happened in Ukraine in 1991. It was enough to declare independence from the Soviet Union and to unilateral self-determination, just one pretext, so-called mortal danger, and refer to 3 victims of bloody GKCP. If you remember, there was on 24th of August 1991, the Act of Declaration of Independence of Ukraine. And there was a kind of formulation, the mortal danger surrounding Ukraine in connection with the state coup in the USSR. Basically, this declaration, this act happened 3 days after it stops in Moscow. Basically, these 3 victims, it was not the case of victims in Kiev, it happened in Moscow. But in Kiev, there was a decision to take the step to the self-determination. Now, let's maybe make a parallel to Crimea. And I see in this what happened in Ukraine. This was a kind of boomerang effect for Ukraine, because if you analyze, it was over 100 people killed in the center of Kiev. Then it was bloody event in Odessa, and of course the situation now in Novorossiya. And the position of our Ukrainian colleagues is nothing happened. It's the same Ukraine, it's not a failed state. It's the same situation, like, so just compare 3 victims in 1991, and basically there was not an idea to save the Soviet Union. If you are correct, you have to remember the idea of Gorbachev to save the Union, so-called Union of Sovereign States, USS. It was the transition period from the referendum in March, and Ukraine was among those republics. It was 9 republics of 15 who declared the will to retain, to keep the common state. It was not already about Soviet ideology, because it was basically another strategic way of state development. For me, it's really now an understandable point from the Ukrainian side. Of course, Ukraine, official government of Ukraine declare always Crimea is a Ukrainian territory. This is Ukrainian population. But all steps what Ukrainian government did all this time show that this is opposite way. For example, it was the fact of cutting off water supply, cutting off of power, energy to Crimea, cutting off of all services, bus connection, transportation, etc. Just remember the case of Berlin. As Soviets and Americans divided city, for Soviet government it was the border, Berlin Wall. For Americans or for Germans, Western Germans, it was just a wall. Maybe you play football like a child at the wall, but it's a wall, it's not a border. And basically here we are speaking about the doctrine of divided people. You have to analyze the population. If you provide this logic, and population in Crimea is due to ethnical structure. It's most Russian-speaking population, over 60% Russian population, plus 20% Ukrainian people, plus 12% this is Tatar people. And just due to results of Ukrainian referendum, Crimean referendum, you have to see these results. Of course, we are in opposite opinions here, but it was clear turnout, over 90% clear vote to reunite with Russia. 96, 97, I'm talking about Sevastopol turnout and general in the Republic of Crimea. So, for me, if you just analyze only in the formal way, I would agree with your logic. Russian lawyers, they have a difficult task to answer to the question. This is exactly maybe our weak position in this situation. But on the other hand, if you analyze what was the beginning, the start of the problem, this was even the situation with a clear breach of this legitimate chain from people to government. Once again, coming back to 1991, it was in March the decision of people to keep common state. Just for me, this decision was a kind of choice of people for unity against separation. The choice against borders, against customs, against establishment of migration law and citizenship, against new national currencies, etc. And basically this was a choice also, as well as Russian people, as well as Ukrainian people. Once again, you can check it up, which was the result of referendum on 17th March 1991. If you believe in direct democracy, this was really a clear message and clear obligation of government to complete this mission until the end. And if you talk about coup d'etat, it was really the end of this year, 1991, as unfortunately the heads of Belarus, the heads of Ukraine, and the heads of Russia declared the Soviet Union dissolved. This was just, as for me, as followers, it was really illegal act. And if you analyze the history, Mr. Nazarbayev, the head of Kazakhstan, he was invited also to Belarusian to this meeting, but he avoided this because he was really in fear that he would be arrested because of total illegality of these actions of Yeltsin, Kravchuk, and Shushkevich. So starting from this point, just come once again to what happened in March. Basically, this is a strange comparison, but in March 1991 it was referendum, and once again in March 2014 it was the second referendum, but in Crimea. And today you can see what is the outcome of this 1991 referendum. Maybe you missed this fact, but in May 2014 Eurasian Union, so-called EU2, was founded. It was the union of Russia, Belarus, Kazakhstan, Armenia. These are those republics who voted for common state. And also additional state is going to join this agreement. This is Kyrgyzstan. So, and for me, you can ignore this outcome of direct democracy in 1991, but you face the situation, and this is not only my conclusion. For example, due to opinion of Gorbachev, the deliberate sabotage of perestroika and thoughtless and adventurous dissolving of the Soviet Union, this was the reason what happened in Crimea 2014. This is direct citation of Gorbachev, the book To Understand Perestroika. How much?
3 minutes.
3 minutes. Okay. So once again, if you ignore the fact that there was a common history, established economic, cultural ties, family connections, etc., you cannot decide about this case objectively. Because if you basically the main maybe problem from the side of Russian international lawyers is to see what happened in interpretation of international law in 2 last decades. Let us take an example. You used always this example, the jurisprudence case law of European Court of Human Rights. The famous case against Russia and Moldova. The case about doctrine that those who are under your jurisdiction, you are reliable for actions against them. Basically, Russia fulfilled this decision, but there was a disagreement from the side of Foreign Ministry of Russia. But take as example another case of jurisdiction, as Saddam Hussein was under jurisdiction of UK, occupied force of Poland, but there was opposite decision. No country, no European country, member of Council of Europe, is reliable for the death penalty of Saddam Hussein. Where is the logic? The same clear, analytical, and blameless logic. I don't see it. The same situation is now. As the Soviet Union, maybe the conclusion, as the Soviet Union was dissolved, despite the fact of clear democratic vote of the people, there was no analytical way, no strong logic to provide the position, stop. Maybe Baltic republics, they have the right to self-determination, and basically with regard to Baltic republics, there was clear use of this historical pretext. Soviet occupation, but with regard to Ukraine, Belarus, and other 9 republics, it was the question, oh, it's against Soviet Union territorial integrity, or to be correct, Union of Sovereign States, the idea of Gorbachev, to keep the Union of 9 republics. Oh, it was also the situation as all the people of these 9 republics were given self-government authorities, and basically it was the case, let them stay in the state because of internal self-determination. For external self-determination, 1991, there was no reason. But how reacted the international community? Very reluctant, and it was supported. It's no breach of international law, no violation of this Hughes-Coggins norm, etc. That's why the last sentence is, I am from Königsberg, and there was very famous position of Gräfin Dönhoff. She was born, this lady was born in Königsberg, and she said, now I learned out how to love without possession. We don't possess Königsberg, Germans, but we love the city, we have connections with the city. And if Crimea is yours, I'm sure if you would support this land, it's yours population, not cutting the supply, water supply, then maybe later or sooner the Crimea would return, but I doubt. Thank you very much.
Thank you.